Welcome everybody to our webinar EPO Case Law update of course in Florac. We are happy that you are joining us today. I hope it will be an interesting 1.5 hours for you. It was interesting for us to prepare that case. Just a few housekeeping remarks at the beginning. So as you've already heard, probably the webinar will be recorded. You will receive a recording. You will receive the recording as well as the slides that we show you within an hour, a week or so. And if you have any questions, just for you to know, please use the Q&A tool of Zoom for any questions you may have. We try to bring them in later on. We will have a short round of questions and answers at the end of the webinar. So yes, I think I have everything. Just as a quick introduction, my name is Matthias Karlhuber. I'm a patent attorney and partner here at Coors and Florac for quite a while now. So I'm originally I'm a mechanical engineer, but I do a lot in the medical technology field, a lot in the IT space, and I do a lot of oppositions. So a lot of that stuff I see every day that we're gonna hear. Then I hand over to my colleagues.
Thank you very much. I'm doing the same he does, basically. With the exception that I'm a physicist. But I got right on track afterwards. So I believe you mentioned everything important for our viewers. And I believe we can quite quickly jump into the cases.
Right. Thank you very much. My name is Svenja Schwand, and I'm also a patent attorney here at Coors and Florac. And I think everything was mentioned before, and we can start.
Let's get started.
That's what we're going to talk about today. Some G decisions, and actually one pending G decision also. And then we also have some case law on procedural and material aspects. And we will start. Oh, it's still not possible to click, I think. No, it's working. With the G1 and G2 from 2022, which were decided this year. And in our last webinar, we already talked about some pitfalls in the transfer of priority rights and some corresponding case law. And now here we had identified a frequent case scenario with US priority applications, which is called the joint applicants approach. And this is basically the case when the inventors are listed as the applicants, and then the international application later lists the inventors as applicants in respect for the US only, and also the employer as the applicant in respect of all other states. And in the past, this was regularly the case when the priority establishing previous application was filed in the US, and this is what we know. And now in these joint proceedings, which the G decisions are based on, and we had a similar problem here. Which led to those referral questions that are based on PCT applications in which the inventors are, on the one hand, applicants of a previous US application, and on the other hand, they are named jointly with two companies as applicants of the PCT application. And in these two cases, the opposition division and also the examining division respectively found that the priority right, the priority claim to be invalid because not all of the inventors who were named as applicants in the US application had assigned the priority right to the applicants of the respective PCT application later on. And here we look at Article 87.1 EPC, according to which any person who has duly filed an application or his successor in title shall enjoy, for the purpose of filing a European patent application in respect of the same invention, a right of priority during a period of 12 months from the date of filing the first application. Yeah, this was basically what those questions were about. The first referral question was to clarify whether the EPC at all confers jurisdiction on the EPO to decide whether a party validly claims to be a successor in title within the meaning of this Article 87, and in particular whether a party B can validly rely on the priority right claimed in a PCT application in the case where this application designates a party A as applicant for the US only, and the party B as applicant for the other designated states. And this PCT application, of course, claims priority from an earlier patent application that only designates party A as the applicant, as we had the case before. Right. And in this decision of the enlarged board, first of all, it was concluded that the EPO is competent to assess priority entitlement, surprisingly.
Yeah.
And yeah.
Please continue.
In this regard, the enlarged board, they distinguished the case between the right to file a European patent application, which is rather based on national law, decided on national law, and the right to claim the priority date for application, which they now say they're competent to assess.
I mean, that makes, I mean, just looking from the result perspective, the competence of the EPO is to assess patentability, and if you do not know what the priority date is, you do not know what the prior art is, and then you do not know if an invention is an invention. So also just from a practical perspective, I guess it makes sense to at least get the EPO some competence on that.
That's absolutely right.
Yeah. Right, and it's also what they found is that there's a rebuttable presumption under the law of the EPC that an applicant claiming priority in accordance with the formal requirements is entitled to do so. That's what they also said. And this presumption, they justified it because all parties involved normally have an interest that the application may benefit from the priority right, and also that there are no formal requirements for the transfer of priority rights, and the applicant of the priority application has to provide support to the applicant claiming priority. That's what they said is the other reasons for this presumption, and this is rebuttable and applies in any case where the priority applicant is not identical to the subsequent applicant, and this is regardless of whether the subsequent application is a PCT application. That's what we talked about before, right?
So we're not bound to this example actually, which triggered all of this. It's a much broader statement.
Right, right, yeah.
And with regard to the second point here, there are no formal requirements. There's actually this funny statement in the decision where it says usually the EPO, of course, always applies the highest standards of everything. But in this case, there's the funny sentence that the EPO should apply the lowest standards possible because, of course, with respect to the formal requirements, they say there are countries which also allow implicit or transfer of the priority right. And so there should not be very high requirements with regard to that, actually. And so that is quite patent proprietor or applicant friendly.
Well, it's a pragmatic approach.
Sure.
Imagine them having to examine that on their own. That's just not. It's just they basically defer it to the point in time where someone really challenges it, an opponent.
And not just with some blind objections, but with some really substantiated
stuff. Yeah. That makes sense.
Yeah.
Kind of.
Right, and that's what they said. It's also applied to this case. For this situation, the enlarged board found that the interpretation of the joint filing of a PCT application is a sufficient proof for an implied agreement on the joint use of this priority right here.
Yeah, so that is similar to the rebuttable presumption in the one case, or the implied agreement, which is maybe also rebuttable to some degree. Yeah, but it's a similar approach for both.
Similar
cases.
pragmatic approach to all that.
Right.
Yeah, think of the pain if that had to be examined, fully examined. So they just apply the lowest standard. Say, okay, good.
Yeah.
There you go.
End of the day,
fine.
you're right. Leave it to the opponent.
Right. Yeah. That's basically it on this decisions that we had this year recently, and another G case of the enlarged Board of Appeal from this year is also the G2 from 2021, which is concerned with plausibility. And here the enlarged Board of Appeal dealt with the question of whether post-published evidence may be used to prove a technical effect, which is decisive for the recognition of an inventive step. And in this underlying case, as you can see here on the slide, the patent which was opposed in opposition proceedings comprised data that demonstrated a synergistic effect of specific claim compounds against 2 moss species, actually. And in the opposition proceedings, this has been opposed by the opponent, who presented some testing results that showed that this synergistic effect is not achieved, actually. And then later the patent proprietor filed further post-published evidence, D21, showing a synergistic effect that against another third species of moth. And it was exactly this question whether this experimental report, which was post-published, could be admitted into the proceedings or not. And this, in view of the board, dependent on the question whether the synergistic effect is against this third moth species is achieved, was rendered, it's decisive if it was rendered plausible in the application as filed before. That was this was about. And here the 3 referral questions that were referred to the enlarged board were: should an exception to the principle of free evaluation of evidence must be accepted, and that post-published evidence must be regarded on the ground that the proof of the effect rests exclusively on the post-published evidence. And this is particularly relevant because the opponent also filed some published evidence to prove that the effect is not achieved, and then later the patentee also filed some post-published evidence to prove the effect for another species. And then those questions 2 and 3 basically relate to the plausibility standard to be applied, and this was decided by the enlarged board. Here they answered that in their opinion, it is in principle permissible to use post-published evidence for proving a technical effect, which is decisive, as in this case, for the recognition of the inventive step of the claimed subject matter. And the prerequisite for this recognition of such evidence is that this technical effect, that's what they say in the second answer here, can already be plausibly deduced by a person skilled in the art from the originally filed application documents. And worded very broadly, the question of plausibility depends on the particularities on the specific case. Actually, this is a quite broad answer, and you still have to look into the case.
But in any way, it's not surprising the insect would have died before of that combination.
Right.
So it's not really that you can reasonably disregard it. It's either deadly for that poor little bug or not. So it's
right. You could say that. And then in summary, the enlarged board has, of course, made a strong statement that the free evaluation of evidence is considered to be a fundamental principle before the EPO. And it has also acknowledged that in principle, you can rely on post-published documents in order to prove a technical effect with regard to this inventive step discussion. And however, as provided in the second answer of the enlarged board, a plausible justification for the existence of such a technical effect, for example, should already result from the originally submitted documents. This decision also made clear that a distinction here must be made between the inventive step discussion and also the sufficiency of disclosure with regard to those post-published documents, in particular because the sufficiency of disclosure is a requirement that the application, of course, needs to fulfill already at the date at which it's filed. And that's also the reason why there's a more strict standard to apply as to whether or not you can use post-published documents to support that, which is a little different here because of the discussion on inventive step here. And finally, the decision also made clear that plausibility is not a separate criteria to the known criteria that the EPO applies, but rather some catchword that comes up in scenarios, especially in the life science or chemistry field, but sometimes also in the mechanical or
that's not excluded. You always have, especially think of some fields, antenna fields or something like that in where you don't know where it's not
what the field look like,
what the fields look like. So it's absolutely possible that something like that also comes up, because in many cases I do a lot in that kind of technology, and the patent application just writes, okay, you've got that field and that it travels this and that way and has this and that property, and it's not really
apparent
that this is actually the case. So and then you run into the same problem. Is it really, can it be that way? Is it plausible that this is what they claim? Because in many cases there is just, you say, oh yeah, it does that. You have this little, well, mechanical alignment feature or whatever, and you apply whatever electrical current to it, and then this is the field. Here we are, and that's the question. So it may well come up with non-biotech, non-chemistry scenarios as well.
Right, and if you would like to learn more about plausibility and this G decision, you might also take a look in the CFWebinar of our colleagues, Dr. Arvid Burichter and Dr. Nathalie Kirchhofer, which will take place on December 14th. And also you can already find on our website a recording of a recent talk of Nathalie Kirchhofer talking about plausibility and what to expect next in this regard.
That was enough biotech for today in the physics and mechanics seminar.
Well, hold on a second.
Public prize, it continues, okay.
We're still a bit in that realm, not biotech, but yeah, if you could move on. So we are with G1 out of 23, which is a very recent referral to the enlarged board of appeal, and it's about public prior use. And the background of that is, well, you see it, appeal proceedings T438 out of 19. The patent itself relates to an encapsulating material comprising a copolymer. And the question was, and that copolymer was published on sale prior to filing prior to the relevant date of the patent. And the question was, what was actually made available to the public? Because as you may imagine, it's not necessarily simple, especially when it comes to composition of materials, to really analyze the component or the material that was out there in the wild for its actual composition. And another point on that, you can't easily reproduce it, because such polymers, you produce them, but you produce them under certain boundary conditions, certain catalysts, certain temperature, and whatever sequence of steps, which has a major impact on how
the results.
Actually, the result actually looks like.
Yes.
You may have it in your hand, but you don't really know. You can't easily reproduce it. So, as you see, it was common ground. It's called Engage 8400, which is a particular polymer which was out there, and but it was not. You can't really easily examine and reproduce it. So the question was, what is it? Is that really made publicly available? Is it made available to the public in the sense of Article 56? In addition to that, it's a bit of a complicated scenario, but there was accompanying documentation that was also available to the public that was sent out. It was some papers and even a related patent document. So that is the scenario. You've got the product that was out there, clearly, no doubt, not questioned by anyone, but was the actual composition really made available to the public? It had everything apart from one component of the claim, which was the composition, or a part of the composition, aluminum, that was not in that particular product that was out there. So it was a matter of inventive step, not novelty, not lack of novelty, but a matter of inventive step. And the question, and it was heavily debated whether or not that was actually the closest prior art. When it comes to assessing inventive step, is it really the closest prior art, or is the documentation that was out there, which was D1, which was this this publication out there prior to the relevant date, was that what was the closest prior art? And you all know Article 52, 1 APC, everything that is made available to the public in whatever way is prior art. For chemical compositions, it is typically stuff that the skilled person can analyze and can reproduce if they have the actual product in hand. And the question is, can they reproduce it with undue burden or not? So that's the million-dollar question for that context. Can you really make it? Can you really analyze it? And what impact does that have? And so what is currently referred to the Enlarged Board of Appeal is as usual, the three questions, the wonderful three questions that we have. It has to be three. There can't be one more or one less. Okay, so it says, is a product put on the market before the date of filing of the European patent application to be excluded from the state of the art, is to be excluded within the meaning of Article 54(2), for the sole reason that its composition or internal structure could not be analyzed and reproduced without undue burden, the wonderful undue burden thing, which is, what is undue burden? We'll come to that a bit later, in question 3, before that date. Okay, so is it prior art or isn't it? The next question was, if the answer to the question is no, i.e. if you can't exclude it from the state of the art, just by virtue of the fact that it is not reproducible and analyzable with undue burden. What is the what about the technical information about that product which was made available to the public before the filing date? Is that state of the art within the meaning of 54(2), irrespective of whether the composition or the internal structure could be analyzed or reproduced without undue burden by the skilled person before that date? Which is a bit of a weird question, frankly, because it is per se, it is prior art. It's out there.
The document as such
is prior art. It's more to the question, can you combine? Because this prior document said, I'm doing this and I'm making this to achieve or to using this particular compound. It
so
was
the connection between.
Yeah, so can you make that, can you build that into a broader disclosure? Not just being confined to what is actually in the document, but make it, because it explicitly refers to that thing that is in front of you, but you don't know what it is totally. Does that is that the combination? But I said the question, in my view, is a bit is a bit weird,
Misphrased.
but yeah, not misphrased, but a bit too short. So they should have said a bit more what they're going at. But at the end of the day, if the answer, question number 3, if the answer to question 1 is yes, okay, so you can exclude it. And if the answer to the question is no, is that state of the art? It's not state of the art, which again, it's be a bit careful about question 2. What are the criteria for finding an undue burden for all that? So this is going to be interesting. Well, as usual, I think they will shy away from it to be
very specific guidelines.
To give very specific, because it's impossible, frankly, and
always.
we'll see that with the next kind of old case, the G referral that we already had covered before. So it's at least we're going to have some guide rails which will give us a bit of a better clue of what that is. But as I said, this can even in my field, it's not that rare that you have exactly such a situation where you have a material, but you don't know what it is and how it is composed, and especially how it has been built. So it's really hard to for many types of materials to really reproduce them unless you have the exact boundary conditions of their production. So it's not, that may pop up very, very often in such kind of constellations. That brings us to the next one. G1 out of 19. The good old G1 out of 19, the aftermath, patentability of computer implemented simulations. And I think it's many of us, I bet many of us are dealing with exactly that problem in today's world. A lot of it, I wouldn't say the vast majority, but a lot of the inventions we are dealing with day in, day out have some kind of computer implemented component to it. It's almost inevitable for most of our clients, for most of us. So it's always worth having a quick look at G1 out of 19 to refresh your mind. So what we have, claim 1, it's a computer implemented method for modeling pedestrian crowd movement. You see it on the right-hand side. It comprises a simulating movement of a plurality of pedestrians through an environment. You provide a provisional path, so something you say, okay, this user or this pedestrian wants to go in that direction. Give it an arrow as you see it on in the drawing. Provide a profile for the pedestrian, something how pedestrians actually behave. They don't walk backwards typically, so they move forwards, something like that, and they don't hop on one leg. So something like that is what you do in that. You kind of provide the profile, you determine a preferred step towards the intended destination, which determination involves a cost of taking that step. So you would not jump across a chair or something like that. So there is always something, what is the least cost, essentially. So you can model that. You define a neighborhood, of course. As you see in the drawing, there's obstacles, there's other pedestrians. That's also, so you've got a moving neighborhood essentially. In the entire simulation, you determine a personal space. Okay, they say I don't want to stand that close to you, so this is what this is what you do. So you always just to see where the cost, that has an impact on the cost, and then you determine whether the preferred step is feasible. Okay, purely in the computer, nothing outside. It's a mere simulation. Nothing happens in the outside world. And the first questions were, you probably have seen it, in the assessment of inventive step, can a computer implemented simulation of a technical system or process solve a technical problem? Because that's always what we are talking about. You know, the famous or infamous convict approach, is there still, you may have technical and non-technical features in a claim, but the technical stuff, does it actually solve a technical problem by producing a technical effect? Where I'm sure many of you have scratched their heads, what is the technical effect in my invention now? What can I come up with? Which goes beyond the simulations implementation on a computer. So you've got a technical system. That's not the problem that the claim as such is technical. We all know that. In the meantime, that is a given. In the meantime, if the computer implemented simulation is claimed as such, so you're just simulating something on the computer. Okay. If that simulation can solve a technical problem by producing an effect, if the answer to the first question is yes, what are the relevant criteria for assessing whether a computer implemented simulation claimed as such solves a technical problem? And is it a sufficient condition that the simulation is based at least in part on technical principles? We've seen that, okay, we defined the environment, we defined the profile of the pedestrian, what they do, etc. If that is it sufficient that the simulation is based at least in part on such technical principles underlying the simulated system? And number three, wonderful number three, what are the answers to the first and second questions if the computer implemented simulation is claimed as part of the design process? So you can imagine you've seen the environment, the drawing. There is, of course, you can design a building, etc., such that it is particularly favorable for having proper pedestrian flow within the building. On the right-hand side, you see a wonderful, very very informative drawing. So essentially, what you have is you have to have some kind of reach to physical reality. And this reach to physical reality can, within the box, which is the computer implemented process, you can have some technical effect within the computer. It's particularly efficient. You're fast. Your calculations are fast. You use less power for processing power, etc. And then, but you may have a reach to the outside of the computer via the input, via the output, and at the beginning, at the end, or during the entire process. So this is this wonderful, very highly complicated drawing that flies around in the context of G1 out of 19. So what are the answers to the questions? Yes. The first answer, of course, it can have a computer implemented simulation can have a technical effect and can, as such, solve a technical problem, which, if it produces a technical effect, and that's what we just had, it has to have that reach to the physical reality. And if that is the case, be it in the processing itself on the computer, or be it in some interaction with the outside world, that this actually is patentable as much as anything else. The next answer to the question is, it is not sufficient. Remember that you just properly describe your system and you use physical rules or whatever. That is not the reach to the outside, or to the physical reality. Properly simulating, properly describing your system does not do the job. So you have to have something more than just having it based on physical principles. And
so it's not just running on a processor, moving electrons because I'm doing calculation. Yeah. That is not the reach to the physical world.
No, this is not it. But I mean, this is why it is technical.
Yeah.
But it's not inventive, because anything runs on a computer. Any software runs on a computer. Yeah. So that's the point. And the answer to the first and second question is no different if it is a design process. So doing the design. The other way around, just doing a design, just saying, oh, I'm designing a house or something, a building, doesn't do the job. You still will have to prove this technical reach to physical reality. So, lovely. What is it? Key takeaways. You can patent computer implemented simulations, or as pretty much as any other computer implemented invention. There is no difference. I said, you saw the picture. Technical effects can occur within the computer itself, but also on the inputs and the outputs, of course. There must, as it says, some direct or indirect link to physical reality that must be present in the claim. And as before, with the responses that we are going to get, what is remember what is prior art or not, what is an undue burden. The Enlarged Board of Appeal said, now we can't really give you an exhaustive catalog of what you need to do, what needs to happen to tick the box for having a technical effect. So it's as such impossible to cover all the possibilities, and that the simulated system itself is technical. I just had that is not good enough. You need a bit more. And again, the convict approach, as we know, the mixed type inventions of technical and non-technical features is clearly confirmed again. So no surprise here. And then you may have seen it, the actual decision that then went back to the Technical Board of Appeals, the T489 out of 14. The main request was just modeling the crowd movement, and they said, no, this is not inventive because it doesn't have that reach. And interesting is they said it does not have an implicit technical effect. So the data that you get out of even the results, the simulation results, don't per se have a technical effect or are only usable or applicable to achieve a technical effect. So that's not good enough. They said it's not inventive. Auxiliary request forward had the wonderful design process where they also said, it does not do anything beyond just getting something that someone else, an architect or whoever could have come up with. So it's just not good enough for having this actual reach to physical reality. And OX7,
it has the measurement.
It
looks like
but it's a hypothetical. It has a hypothetical. So it just had the measurements to especially for the pedestrian behavior. So they measured behavior, basically put that into some values. So it's not a real-time input, for example, and we will see that in another decision. So that was not good enough as well. So it's because you measure and which helps you in describing what essentially again what the system
should look like.
It's a proper description of your system of your system component, which is a pedestrian at the end of the day.
But it's not like real-time input data or something like that.
It's not real-time input data. It's just so the measurements. That's why I wrote hypothetical measurements. It's just something that you actually. Not a real input, because that we would see may have an impact. So we can go to the next one. We've seen that. So it's just again reach to physical reality, solve a technical problem. Think of it. In many cases, you can come up with something that's really, and if it's just in very often. At least in my experience, I just had that a week ago. It was that you could say, okay, you could show you did the algorithm was less complicated. You had to perform less steps for calculating something. You saved some steps, which means processing is faster, which means less power. That is something the EPO, the examiners are looking for. And are convinced by. If you can show them, okay, my system needs less power, needs less steps, is faster. That is something that typically convinces them. Good. Let's go to the next one. T16, 18 out of 19, something that has been decided, a decision that has been issued earlier this year. The claim was auxiliary request 1, a blending control system in a refinery, and it had a computer modeling apparatus modeling the technical system, had a processor routine that determined the sequence and timing of the operations to provide a new value range to parameters and variables to control the blending. Okay, so they said, yep, fine, you feed, and then that was, it was really fed with parameters from a running process.
Mm-hmm.
Okay, so that was the first reach to physical reality that they said, okay, that's fine, that's good, that is technical, that is a technical component of that, and to convert that calculated process parameters into control signals, that is what they considered, a direct link with physical reality, because at the end of the day, that's what you're there for. But the interesting bit of it, and that's why I highlighted that before, it's not a mere implementation of an algorithm on a computer. And they said, the second bullet point of the decision, it's not really relevant that the claim does not require the actual use of the control signals, because the claim just said, I'm providing these parameters for generating control signals. So it didn't claim
controlling.
It didn't claim controlling. It didn't claim, okay, and then feeding these control signals into my control. Okay, that was not required, and that goes a bit to the question: is it the only reasonable use of that? Is what the signals are there for? I mean, you will not use the signals to control your lighting. That's not reasonable. But they are designed and configured to actually be fed into a control. So they said that is good enough. It was really not relevant. They said it's irrelevant that the claim does not actually require this. They made a remark that it would have been better if you had said that, if you had claimed that. Yeah. It's explicitly in the decision, but they say, okay, but nevertheless, it doesn't matter. And they said, then the technical effect. Okay, good. We've got the wonderful control mechanism, and there is differences, but just in the algorithm. The only difference the technical difference that you had just like exclusively in the algorithm that they are using, how they are configuring certain calculations. And they said that is good. The effect was here in that specific case, it increases the robustness of the schedule of the timing at the end of the day. And they said, good enough. That's perfect. We're happy with that, and they found it inventive. So that is, and it just said, it's an interesting. You may want to read it. It just says that it is basically you configure the algorithm such that it is reluctant to make changes. Okay. So it's basically it's a lame and lazy algorithm. So no, I don't want to change something. But at the end of the day, that did the trick. Yes, that was something that was a difference over the prior art, and as it said, it increases the robustness of the schedule. And they said, good, perfect, done. Next one. Okay. Adapted visual vocabularies. Wonderful. Read the claim.
What are those, Matthias?
You will absolutely love it. It took me a while to figure it out, but at the end of the day, what it is about, it's about object re-identification. You've got cameras, and as it says here, it says it's a method for object re-identification comprising to obtain a first and second camera-dependent generative model. So you basically you've got your camera input, and you basically model something. You have your generative model, then you modify that, you extract a first and a second image level descriptor, so kind of some features from the image data, from the raw image data. That is a so-called Fisher vector. Don't ask me what that is, but it's...
I won't.
You won't. Hope no one accept that. Okay, and computing a similarity between the first and second image level descriptors, and then providing an indication that the first object and the second object match. The example given in the application or in the patent is a real world example. It's comparing license plate. Everyone knows that you go to the airport, You drive next to the camera, the gate opens, you drive in, you leave, hopefully within the time you didn't have to pay or you have paid, and then the next camera. And of course, you never have the same lighting conditions, never have the same lighting scenario there. So the system, the image recognition system has to deal with that. The decision said, good, fine, re-identification of objects captured by cameras, and that's all it does. So it's totally internal, yeah. To the system. Okay, you get in an image, but the rest of it only happens in the within the algorithm. That is a technical purpose.
Mm-hmm.
Now the question is the technical effect achieved over the whole scope of the claim? So do you really, and that is again the thing that we had, is it really kind of, is it the only purpose?
Yeah, the only use case.
Is it the only, or is an effect achieved? Can I really achieve this recognition, this re-identification with those data? And the very interesting decision, they said, yeah, the example with the license plates, it confirms that the effect would be achieved for similar conditions. They said, okay, lighting and the object geometry. They said, yeah, that is good enough. They said, you may always come up with something where that thing doesn't work. If you imagine an object that doesn't have any contour, that doesn't provide any contrast, you can't make it. You can't just make it. But they said, the board said, yeah, but the skilled person would know, I can't apply that to it. It's not reasonable to say, yeah, but you don't achieve the effect. So they took, actually, which is really fascinating and interesting. They said, okay, it is good enough. Given the teaching of the patent, the skilled person would know, okay, I need to have certain boundary condition. I need to have something that provides contrast in order to do image recognition. And they said that is good enough.
Okay.
That is good enough for us to find that this technical effect of the whole scope condition is actually met. And then they found the difference, which is an additional use of those wonderful Fisher vectors that was not known from the art. They were known, but they were known as an alternative to something the claim had as well, the generative model, but not as an addition. And they said that was good enough to justify non-obviousness, and they essentially found it inventive.
Okay.
So they didn't interestingly, they didn't formulate an objective technical problem here, but as we all know, the objective technical problem is to come up with an alternative solution, as we often have it if we don't have any better. So it's basically what they did and said, okay, good enough. But very interesting, especially the fact that they say, yeah, given the outline of the patent, the skilled person knows. They said one sentence is, in fact, no image recognition process can solve every image recognition scenario. They can't deal with anything. So in reality, you always know you need you're working within certain boundary conditions. As said, no contrast, no image recognition. Yeah, but still, I mean, it's good to have that on paper from a Board of Appeal.
Yeah. We'll actually come back to this entire scope and reasonable use cases for a claim in the very end, actually.
Yeah. So that was it.
So stay tuned.
Stay tuned.
Yes, so now we're leaving the G decision realm and are coming to some T decisions, which have all been published during the last months, basically. And well, a lot of them will deal with admittance and late filing in the appeal proceedings, as is
we all painfully experience.
Yes, just like an aftermath of the 2020 rules of procedure, but we also have other T decisions on some further points. But we'll start off with this one, which I gave the headline "Two Types of Burden," and it deals with the insufficient disclosure, basically, where usually, or basically at the beginning, the opponent has the burden of proof that something is insufficiently disclosed, because the opponent, the proprietor, can rely on the granted patent and the grant and say, well, the presumption is that it's sufficiently disclosed, and now the opponent has to provide facts, arguments, evidence against this. And indeed, the opposition division found that the opponent was right, and that the patent is insufficiently disclosed, the invention is insufficiently disclosed. And then we are, of course, moving on to the appeal procedure. The proprietor appealed. And then the question is, what is the level or the standard for the proprietor? What does he have to bring forward in his grounds of appeal? Is now, that's what at least the opponent, the respondent's view was, that, well, now we have a different situation. The opposition division has already said it's not sufficiently disclosed. So now the burden of proof, the ball is again with the proprietor. He has now to provide corresponding degree of proof and evidence against what I said and what the opposition division approved, basically. But that's not what the Board of Appeal said, basically. Rather, well, the proprietor just has to fulfill the usual burden of substantiating the case. So in his grounds of appeal, he can just state, well, the burden of proof was actually not fulfilled by the opponent. I don't have to really react to that, apart from maybe arguing that this was not the case and the decision was wrong. The burden of proof is not on my side, and that's what the Board of Appeal said. And in fact, the Board of Appeal also said agreed with the patentee and said, well, the invention is sufficiently disclosed, and the burden of proof was not met by the opponent in the first place. And of course, that only learned the opponent in the summons.
In the summons of the board, in the preliminary opinion of the board.
Yes, and so he, of course, this triggers to provide further arguments and evidence and facts to achieve this burden of proof, basically. Now still relying on the opponent, basically. But then you again have the problem of the appeal procedure, that providing evidence after the summons.
It's an amendment. It's considered an amendment to your case, which means, which is at the end of the day, post summons, not only post preliminary opinion, is to be rejected by the Board of Appeal.
The second
and
level.
That's what they did. They just said, no, you're too late now. So that's
that turned around quickly.
An interesting takeaway from that as well.
Yeah. So the burden of proof does not shift already, because the opposition division may have found an invention to be insufficiently disclosed. And you also need to consider whether maybe further proof is needed already in the response to the appeal, the first opportunity for you to react, because later on, as always in the appeal proceedings, it may be too late. And here it's especially tricky, because you don't really know if you.
No, you never know. This is the thing. This is it's a major problem. It's something you will probably also already have experienced. Do not rely on the fact that the opposition division followed you.
Yeah.
This doesn't help you in any way.
Yeah. It's the same with the preliminary opinion and the decision, and
whatever it is, the boards of appeal, or many of them, will tell you the issue was on the table.
Yeah.
It is up to you to frame your case, either with the grounds of appeal or with the reply to the appeal. This shapes your case. And if for some reason we do not follow, which is always something you have to factor in, the opposition division, it was up to you. You could have said it. And if you didn't, you're toast.
Yeah, that's the gist of it.
Yes.
Indeed. Okay, so this one, talking of late filing, briefly
Also very interesting one.
remain at this issue, basically Article 12 RPBA. So in this case, we had, or the boards of appeal had to decide on the admissibility of an auxiliary request, which was filed in the first instance during the oral hearing, but it was not discussed. So the proprietor filed multiple ones during the oral hearing, as far as I understood, and they decided that one of those new requests was allowable. So there was no need to continue down to the lower ranking request. So it was basically filed, but it was never discussed, neither admissibility nor allowability, of course. And so the Board of Appeal now has to basically determine in what kind of state is this filed but undiscussed request. And it is at least not Article 12.4. It's not part of the first instance, in the sense that it was part of the decision, because it was never, it's not mentioned in the decision.
Well, it is mentioned,
that in the minutes, or that it was filed.
That it was filed, but it was never
discussed. That's the point. So it's not part of the proceedings in that sense. And there is, of course, the option that it is still part of the appeal proceedings, according to Article 12.4, this unless case, unless it was admissibly raised in the first instance. And you could think that this may apply. But the problem is that now the Board of Appeal has to examine whether this admissibly raised applies, and for this there are basically the usual criteria, which also apply in the first instance. But there's one subtle difference, especially here, the last one, the convergence of the claims or the auxiliary requests, which is not that big of a deal in the first instance, but more of a deal in the second instance. And when the Board of Appeal now looks at this request and sees, well, that's a completely different line of defense, they quickly can say, well, that's not convergent to what was there before. So we don't see that this would be admissible. And then this request was also, not allowed to the proceedings.
Not admitted into proceedings, but keep in mind, this is a specific situation, or a specific, it is about a request that was filed at the hearing, at the opposition division hearing. So not within the time limit that you're given.
Yeah, so it was already late.
It was already late, and it was never discussed. The case might look a bit, most likely look different if that request had been filed in response to the preliminary opinion of the opposition division within the 1 or 2 month deadline, typically 2 month deadline that you're given prior to the hearing. So that would have changed things. But as it was a request filed on the day of the hearing, and the later request, so which was actually not discussed, that triggers this specific, or at least adds to that specific scenario.
Yeah. So filing a request does not mean that it's part of the proceeding, and admissibility will be discussed later on, and more strict requirements may apply if you discuss it later on.
Has not discussed it.
Yeah.
There would have been no discussion if you had filed it within the time limit for filing it. So then it is in. Yeah. But at that point, at that late filed stage,
it had to be decided still.
Yeah.
Yeah. And I think we're still sticking to Article 12.4 for a second.
Our best friend.
Yes. I think that's the last one, maybe. So here we have the situation that an inventive step attack was brought forward against a specific request, AUX request 2, and in the grounds of appeal then, the opponent wanted to basically apply this attack, lack of inventive step attack, also to the main request. And the question first is, this attack against auxiliary request 2 was already introduced very late in the proceedings in the first instance. So can we review this decision to admit this request, basically? And there the board does not see a basis for, if it is once admitted and discussed, to again carve it out of the proceedings. If it's admitted, it's admitted. So this way it doesn't work. But of course, the other way around, if it's now applied to the main request, which was not the case in the first instance, we of course have to discuss whether such an attack should now be
admitted, yeah.
Admitted, right? And yeah, first they confirm that this is also an amendment to the case, but in this case it is quite apparent. I believe the requests were indeed convergent in this case. So
which
the
is
main
a specific
request,
case, which
yeah,
is a specific case because you don't always have that.
yeah.
So
True.
this was the request against the aux request 2 or
Mhm.
what against this attack was raised was a clearly restricted claim over the main request.
Yeah.
So it was not something different, which may just change the whole spin to that if it was something different. But here it was clear. It's just there was just features added to the independent claims.
Yeah.
So
it's just logical, common sense to see that. Well, it of course also applies to the main request.
If it takes away an
Yeah.
inventive step for that narrower claim, that it also does the same thing for the broader claim.
Yeah.
But I said very specific, could look totally different for if the requests were framed differently.
Yeah. So keep in mind, specific attacks need to be admitted at discretion of the board.
Oh, yeah.
In the worst case, and so wisely consider all possible attacks as always in the first
As
instance.
In the meantime, yeah.
Yes. So now a brief, maybe a no-brainer for in between. Just a confirmation of established case law, basically, but something that still regularly comes up if you're dealing with prosecution
Especially
cases.
Prosecution in examination, you
Yes.
hear that, oh, that's unclear.
Yeah, and here as well, the proprietor, the applicant heard the objection from the examining division that the claim left open very many features. It was not clear how this is done, how that is done, and the board again clarified, well, the claims may be broad, but they are all technically reasonable, and broad claims are not per se unclear, and complex claims also are not per se unclear. Of course, this has an effect on the inventive step if your claims are broad, as always. You may run into issues there.
Prior art documents.
Yeah, but just because your claim leaves open how something is done, that doesn't mean it's unclear. And here's just one more decision from 2023, which you can cite in your response to the office action, basically. Yes. And this is one, yeah, I mean, if we look at 123.2 disclosure, the EPC is actually already quite clear in that not only for your application, you can take your application as filed as your whole reservoir, but also if you already have a patent, then 123.2 also states that you can go back to your application
the original
as filed.
disclosure.
And because that was relevant in this case where the opponent argued, well, there is no disclosure for the amendment of the proprietor because this feature is not in the granted claims or the granted patent. And the board said, well, that is not relevant because you can go back to your application as filed. But you may be careful with this because there may also be amendments to the patent upon grant, amendments from the examiner maybe, which clarify certain things, which remove a definition. And for those things, of course, it may not be possible to go back to your application as filed because you may, if you reintroduce a definition which broadens something, then you have a problem with scope of protection.
So this is a very serious issue that is often overlooked. You get a 71.3 notification, an intention to grant, and they tell you, yeah, okay, good, we love your claim, but we don't like your description because there is so much stuff in there which is not according to your claim. And they happily delete pages and pages of that stuff, which, while in the first place might be okay, because, well, if it's not, and you might think it is okay, because it is not, it's not going for your claim, and possibly you're happy, oh, I'm getting a patent. So this is, I'm accepting that. But this is very dangerous because, okay, you're in that scenario where the opponent can say, yeah, but there is no basis, which is not right, for at the end of the day, for making the amendment, for going back to the original disclosure, despite the fact that this passage in the patent has been deleted. I mean, it begs the question: why did you delete it? Why did you have to delete it? If you go back to that, but the tricky bit is actually this Article 123.3 issue, because at the end of the day, the scope of your claim, to some extent, is defined by what you have in your description. And if stuff has that justified some specific interpretation, construction of your claim, you happily deleted it from your description, you can't bring that back in, because that then broadens the scope of the claim, of the granted claim.
Or may.
Well, it
depends, of course, but
it depends, but
otherwise
that is a real risk. So I really recommend be careful when accepting deletions of your of parts of your description.
And another issue which comes in is the last point that, of course, national courts, if you have a EPDE, EP, GB, FR part of your granted EP patent, they may see this differently, as in Germany, the examiners in limitation procedures like to refer to the so-called Zäsurwirkung, the caesura effect, like a breakpoint upon grant, where you cannot go back further in time, which is, I think, not undisputed, but you may encounter those problems.
It is a fact that they handle it that way, and it may turn out to be a problem. So it's something to really be aware of. Of course, I know it is a pain if you go for if you have a 71.3 notification and you say, okay, good, I don't want to mess around with my description too much. I just accept what the examiner is giving me. Rather, just try to convince the examiner, say, no, this is not right for this and that reason, and this is a very good reason for saying so. It is not just something you should take lightly, because it may get you into trouble. The only thing what you then have to do is go through all your description and say, okay, this is not according to an invention, but at the end of the day, and it may be a bit esoteric at the end of the day, but we are
but in the end,
the complicated cases are the esoteric cases at the end of the day, where you actually say, okay, but this may get you into a 123.3 issue, so broadening the scope of the claim, which is, well, you're out at the end of the day if that happens. So it is really worth taking the pain and just streamlining the description in that sense, rather than just blindly deleting stuff. And always be very careful with proposals by examiners.
Sure. So back to the opposition proceedings. Here we have
lovely one.
two cases which I titled "Use the Break Wisely," and here we have two cases where the preliminary opinion was overturned, so the opposition division changed its mind. Always a bit stressful for the patentee. And here, new requests needed to be filed, so there was a break of 45 minutes. And there were, in fact, replacement requests filed. And then in the appeal, the proprietor actually came up with further ideas and tried to file auxiliary requests 2 to 6, which were new, so not filed after that break. And the board here has the clear view that this break, which you can, of course, find at least in the minutes, could or where the opportunity where the proprietor could and should have filed these new requests. And similarly, in the second decision here, we also have the situation that issues came up after the main request, which was not allowed. And then there was the usual lunch break, where the proprietor could reflect on how to proceed, and but the proprietor decided to continue with the requests on file, basically, and then also try to file further auxiliary requests on the
Later
appeal.
later in the
Yeah,
day,
yeah,
not straight away, but later
Yeah.
in the day, and that's a dangerous thing.
yeah, and
They may, if you try to do that at 6:30 in the evening,
Hmm.
the motivation of some opposition divisions is very low to let you do this, despite the fact that you knew what the issue were.
yeah, yeah. So especially those longer breaks are usually considered as an opportunity to react on anything which is on the table.
But just to have a great lunch.
Yes, up to that point. And also for the boards of appeal, they will look into the minutes and look whether you had this chance, and
whether you took it,
whether you took
whether you applied due diligence to do it. And we come to the next one. I think is
a counterexample, so to say,
but reasonable. It's just what can be expected. From the representative of patentee or an opponent.
Which informal title is the request 19 hours 41, which was the name of the request, because I don't know.
It was filed at 1941.
Yeah, but it was not request 3, it was the request 1941. And that's as you say, was the time at which this request was filed to overcome certain objections which became apparent during the opposition proceedings and during the hearing, and which also used features from the description, and for the first time had some elements in it which the appellant, then the opponent, then considered as unclear, but and he was given half an hour to review those new requests, and this clarity objection he only raised then in the appeal proceedings.
In the appeal.
So he didn't notice them right away during the oral hearing in the first instance, but only when drafting the grounds for appeal. And then, of course, the question is again, are those now newly raised clarity objections to be allowed? And the board says first, again, rather strictly, well, it would be possible for you in that half an hour to spot those clarity issues. But on the other hand, the Board of Appeal, in the end, they appear to be human. They say, well, of course, it's a bit a tight time frame. It cannot be demanded to maybe spot some intricate clarity issues taken from features, taken from the description for the first time in 19:41. So in that case, it is fair to allow such objections. So it is possible to introduce them, especially in those if you can show that you have those tight timings.
Yeah, but at the end of the day, this is an example where that worked, and where the board had mercy with the I think it was the patentee, but don't let it come that far.
I
mean, I've had that situation. I had a patentee. I was an opponent. And the patentee finally at 1930, so mine would have been the 1930 request. They came up with the first request that actually met all the added matter and sufficiency, solved all the added matter and sufficiency problems. And DOD said, happily took it in and said, okay, good. So now we discuss novelty and inventive step, and which is totally crazy. It's 9:30. It's 7:30 in the evening, and my reaction to that, and I can only recommend that. I said, no, we're not going to discuss now at 7:30 in the evening novelty and inventive step for the first request for the first time in the entire day after more than 10 hours of hearing. And I said, I will not accept that. Otherwise, I would say my right to be heard has been violated. And finally, they didn't love it, but they adjourned the hearing, and we went for another date to continue with the hearing. This is what I can really recommend, because seriously, you can't do a major part of the discussion, novelty and inventive step at that time, within that short. At that time of the day, that just doesn't work. And I think at the end of the day, everyone understood it. It didn't have to argue that long with them. I had to, but still, that's my recommendation. If you ever run into that kind of problem, just request adjournment. That's as they said, you could have spotted it, but it's totally understandable that you didn't.
Yes.
Right.
At that point in time, and you don't want to have to rely on a Board of Appeal saying, yeah, okay, good.
Yeah.
That's not fair.
Yeah.
So,
but they really, so also recently I had oral proceedings where it was also relevant what happened in the first instance and how much time and opportunities somebody was given. And the deliberation of the board took, I don't know, 1.5 hours, because they really tried to recreate from the minutes and from everything what happened and which chance was given to whom, which also makes it clear that the minutes are maybe quite relevant, that they are correct, especially for those late filing issues. If you want to show I was only given a very short amount of time, you should take a look at the minutes.
That is another recommendation, really. It's ever more so with the rules of procedure now before the Boards of Appeal. Have a close look at the minutes, because they will go back to the minutes. What did you say? What did you raise? And if you think you have an important point, make sure, ask the minute writer to actually put that on the minutes, request it. I just had that 2 days ago. I said, would you please put that on the minutes, because that bites you. If something is not in the minutes, you're out. How can you show that this has happened, and that you've said that this has been discussed? Typically they are okay, but it's not necessarily the case. So really have a look at it.
Advice, yeah.
Okay. Oh, so deleting claims. So this time, I think last time we talked about deleting independent claims, which makes sense to have, like, if you have better chances with one category than the other, the method claim, the apparatus claim, may be easier to distinguish from the prior art. But sometimes you also need to delete dependent claims, because only the dependent claim was redrafted and may have 123(2) issues or so. And in this case, the board first clarified that also deleting a dependent claim is, of course, an amendment of the appeal case. However, in that case, the situation was that the objections against this dependent claims were indeed already raised in the first instance in a submission shortly before the hearings. And there was also some sort of question from the first examiner regarding this issue, but the board in that case said, well, it was not really apparent in this quite short oral hearing of an hour and 75 minutes, whether you really would need to react to this and whether this was really an issue regarding the maintenance of the patent. So in that case, the board admitted to delete the dependent claim. I can imagine that maybe the willingness to allow those kinds of amendments are still reasonable and
but it depends
present
on how far the annoyometer is with the Board of Appeal. If it's well in the red range, then you might end up with
be able to delete a dependent claim.
I've had that with an independent claim, where the patentee was just he literally visibly annoyed the board, and they said, "Nah, come on." At some point, he would just wanted to delete an independent claim, and said, "No, we won't let you do this. We've got this is an amendment to your case. Late filed. Done."
So even if it may sound stupid to you to delete a dependent claim as a request in the first instance, because you think, oh, I can do that later. It's wise to also have
think of it at least early on in the appeal procedure, or not as the last resort after a long hearing with the Board of Appeal.
Okay, now we have an Article 84 decision. So Article 84 is actually known for clarity, but the article also states that the claimed invention needs to be supported by the description. And in this case, the appellant said, basically the opposition division said it was, the examining division said that it was not supported, specifically because there was a passage in the description regarding the technical problem, and it said that there would be a detection of rotational positions, and there would be some sort of improved detection accuracy. And the problem was that claim 1 was quite broad, specifically regarding this magnetic device, which should do the detection, and the geometrical implementation was left open, and it was apparently, or it was apparent from the description that certain restrictions would need to apply to achieve this aim. And so they concluded that the claim is actually not supported by the description, and so the board concurs with the findings of the examining division, and the proprietor then, which is the appellant, tried to react to this opinion and filed additional auxiliary requests, but again, as before, too late, and there were no reasons apparent why this was not already done in the first instance. I thought this would be a interesting case that a quite specific technical problem can lead to issues with the support criterion on Article 84. So think about how you define your technical problem, maybe not too ambitious, maybe have some alternative technical problems defined, which are not that strict.
Yeah.
Okay, so now the sufficiency case in mechanics. So maybe first having a quick look at the claim. It's about a rolling mill and about the detection of a malfunction. And the malfunction should automatically be identified, and also the duration of the pause emerging from this should be determined as a function of the type of malfunction which is detected. And the opponent said, well, it's not sufficiently disclosed. And there was, in fact, an example in the description how this is done. It was discussed that there are some sort of typical malfunctions, and there was a matrix where you could say, well, when this malfunction appears, it takes so and so long to fix it.
Known malfunction scenarios at the end of the day.
Yeah, and for this, the opposition division said, well, there is at least one way of carrying out the invention, which is the usual criterion in Rule 42 EPC, and the opponent came up with some exotic scenarios which would also fall under the claims, and the opposition division said, well, those are kind of exotic cases which are not relevant here.
Airplane crash.
Yeah, exactly. And we have it down below there, airplane crashing into the rolling mill, nuclear bomb.
Which happens every now and then.
Yeah, and the Board of Appeal then said, well, at least one way of carrying out is, of course, a necessary criterion according to Rule 42, but it may not be sufficient. We also have the criterion of the end of being sufficiently disclosed over the entire claim, as we heard earlier, with respect to being inventive over the entire claim. And there were some doubts apparently during the proceeding whether this criterion is actually applicable at all, because it is usual practice in the field of biotech life science. And here the board clarified that also this entire claim area criterion for sufficiency is applicable also for the mechanical arts, basically. And then, of course, the question is, what is with those exotic things like airplane crashing on the rolling mill? Does that need to be detected automatically? And so the board came up with some.
You have a long downtime. Crash on your mill, I'd say.
So the board came up with some additional filter, basically, like the technical reasonable embodiments, which the skilled person would consider to be a part of the invention and which would be reasonable embodiments. But no such theoretical interpretations. And those examples of airplane crash you are in the realm of those theoretical embodiments where you would say, well, that's not what the core of the invention was. But we came up with, the opponent came up with a malfunctions which is unknown. And there was the problem that the patent did not have any thing disclosed if it didn't know the type of malfunction beforehand, how this is to be detected and how the duration is to be determined. So it was in the end insufficiently disclosed. And I think that was also our last.
Brings
So
us to the end.
Wrap up.
Yes.
Thanks for staying with us now, and we hope you enjoyed it and look forward to seeing you at the next one. Thank you very much. Have a good evening.
Bye-bye. Thank you.